for the civil motion hearing docket this morning. We have several cases on the 10 o'clock docket. The first one I'd like to call is Andrew Guidry v. Catherine Atkinson. Do I have the plaintiff present? All right.
Can you hear me, Your Honor?
Yes, I can hear you. Did
Okay.
I pronounce your last name correctly?
Guidry, yes, sir. You did great. Thanks.
Guidry. All right, very good. All right, and do I have counsel for the defendant present?
Yes, Your Honor. Good morning.
Good morning, Mr. Batista.
Good morning, Your Honor.
All right, this is case number 21 SC 679. Give me a moment to pull that case up. All right, we're here on defendant's motion to strike. Is that correct?
Well, motion to dismiss, motion to strike, and a motion to reset the pretrial hearing, but I'd like to start with the motion to dismiss due to illegality of the contract.
Your Honor, I object to that. I think that the most pressing issue is the motion to reset, because that's the crux of this entire case. We wouldn't be here if not for that motion.
They're all set for today, Your Honor, and they're my motions.
Correct. All right, Mr. Batista, you may continue.
I'd like to, I don't know if you have the motion to dismiss due to illegality of contract before you, Your Honor.
I do have it.
Basically, the contract, if you read it, it states in the contract that the only reason the contract exists is because the parties want to defraud the state of Florida of sales tax for the sale of a car. I mean, it can't be any clearer than that. I mean, it says it right in the contract. By law, we have Florida statutes 212.05, which I cited in the motion, which states that any attempt to change the sales price of a vehicle or to otherwise defraud the state of Florida of its sales tax is a criminal act. It's a misdemeanor of the first degree pursuant to section 775.082 or 775.083 of the Florida statutes. Therefore, it's a crime. What is stated in the bill of sale, which is the contract that Mr. Guidry seeks to enforce, is a criminal act. Basically, that's the whole. I mean, it says it right in the bill of sale. There's nothing needs to be interpreted. It says it there that this contract was created so that they can avoid paying the sales tax. And by Florida law, and I stated case of Jupiter Medical Center versus Visiting Nurse Association of Florida. Illegality is a compelling reason not to enforce the contract, and it cites some cases. I don't know if you're reviewing if you have that in front of you, Your Honor.
I do have it.
The principle that courts will not enforce illegal contracts is well established. There can be no legal remedy for that which is itself illegal. Indeed, there rests upon the courts the affirmative duty of refusing to sustain that which by the valid laws of the state, statutory or organic, has been declared repugnant to public policy. That's basically the whole argument and the law which we put into the motion, which you're having the opportunity to review. The contract, I mean, it says, I mean, did you want me to go over
I
that?
object to this.
Mr. Guidry, let Mr. Batista finish and you'll have an opportunity.
Oh, yes, sir. Okay, I'm sorry. I didn't know.
You read the bill of sale. It says it right there. The buyer confirms that she requests the purchase price reported to the State of Florida Department of Transportation certificate of title be listed as 100 so she may avoid paying large sales tax. So, I mean, that's right in the document that he seeks to enforce, is the fact that it's created in order to violate Florida law to defraud the state of Florida of sales tax and to commit a crime, which makes it a contract that the court cannot enforce, Your Honor. That's basically the crux of the argument. Thank you.
All right, thank you, Mr. Batista. Mr. Guidry, any response?
Yes, sir, I do. That statute clearly says that this is intended for contracts greater than a dollar value of $9,200. The defendant still owns the car. She still drives it to this day. That contract was made in good faith. She asked to alter the price, and then as a courtesy, I did that. I'm not a lawyer. I'm not trying to break the law, but this contract was done in good faith, and she simply has chosen to ignore it. And this dollar value is well below that $9,200 mark. That statute was meant for corporations, sir, not for two people selling a car. So it's disingenuous for the defendant to suddenly claim now that this contract is not valid. She's had this for years, and she's made no effort to pay on it. And now this argument about the contract is suddenly not valid is not a good one, Your Honor. And I would ask that the court not toss out this contract, as it was made in good faith, and she still has the car. So, thank you.
All right. Any rebuttal, Mr. Batista?
Well, first of all, the fact that this gentleman who's filed probably 30 lawsuits on his own, and he probably knows more than any normal paralegal about.
Jack, I'm not an attorney.
He's
all right.
I'm sorry, Your Honor. Being facetious when he says he's doing anything in good faith. He sued his own wife dozens of times in the process of the family law case, which is why during this family law case, the post-judgment phase, because she's seeking more parenting time, he has sued her 3 times, twice in domestic violence court, which have been dismissed, and now in small claims court. And this is the last thing it is in good faith. The bottom line is he knows, the contract itself says he's trying to commit a crime, which, it's hard to say that, he couldn't understand that when he's putting it in his own agreement. That he's trying to avoid paying sales tax. How can he say that he didn't know what that meant when he's the one that prepared the agreement? So the bottom line is, Your Honor, there's a presumption when a title is signed that it was purchased. This agreement that he came up with, basically he says this lady, the defendant has been driving the car for years. And as you can see, the agreement is from 2018. So it also doesn't make sense that years after this transaction happened, they would sign this agreement. But that's there's so much wrong with this case that, that's why we filed 3 motions. But this is, I think, the most blatantly obvious reason to dismiss this case is because the agreement itself says it's basically trying to commit a crime.
Your Honor, he says that she's been driving for years, 2018, 2019, 2020, 2021. That is years, plural, not before that. Okay, so when she took possession of it, that's when she started driving it, and she's still driving it now. And this contract was something that was found on whatever kind of a Google website. I'm not an attorney, and she's the one who's trying to avoid the sales tax, not me.
All right. Having heard the arguments from each side, having reviewed the bill of sale as well as defendant's motion to dismiss, I find that the bill of sale is an illegal contract, and I'm going to grant the motion to dismiss.
Thank you, Your Honor. I will prepare an order if that's all right with the court.
Yes, Mr. Batista, if you'll prepare the order in Word format and send that to my judicial assistant.
Thank you, Your Honor. I appreciate it. You have a very nice day.
Thank you. You too. Thank you, Mr. Guidry.
All right, Your Honor. Thank you. Is that it?
That's it.
Okay. No other motions? All right. Bye-bye.
Thank you. All right, let's see. We've got Carfax v. Fair Price Auto, case number 21CC25.
Good morning, Your Honor. Robert Lindeman for plaintiff.
Good morning, Mr. Lindeman. And who do I have for the defense?
Good morning, Your Honor. This is Anthony Gonzalez representing Fair Price Auto.
All right, good morning, Mr. Gonzalez. All right, let me pull that case up. All right, we're here on the plaintiff's motion for summary judgment. Is that correct, Mr. Lindeman?
Yes, Your Honor.
All right. Go ahead if you'd like to proceed.
Thank you, Judge. And as you said, this is plaintiff's motion for summary judgment. We've attached in the affidavit of support that the amount claimed in the lawsuit is due and owing the $10,166 in principal with no other offsets or credits due. Fair Price Auto did file what appears to be a pro se answer admitting to the existence of a contract, but otherwise I think it's safe to say generally denying the other allegations. Because we're in county court, the defendant is a corporation and it was filed, looks like without counsel. I'd argue that under the rules, it's a nullity and therefore shouldn't be considered by the court. What we did, however, Judge, is we moved for summary judgment instead of default to see if we could get a response. Fair Price Auto has not responded to the motion for summary judgment. There's no affidavit in opposition or any other response that might preclude summary judgment at this time. Based on the status of the pleadings and the motion, I don't believe there's any genuine issue of material fact at this time, and plaintiff would be entitled to judgment as a matter of law.
All right, thank you. Mr. Gonzalez, what's your relationship with the Fair Price Auto?
I'm the owner of Fair Price Auto.
All right. Have you sought counsel in this matter?
No.
You understand that as a corporation, you have to have an attorney in a civil suit?
No, I wasn't aware of that, Your Honor.
Do you have the ability to hire an attorney?
I don't have the financial ability to hire an attorney right now. Your Honor, this the motion or what they're trying to present, it is something that was very unfair and a deceptive ad from the representative from Carfax. They sent their representative to my office to give us some information that was very incorrect to what they presented at first when we first signed up for them. And they told us that we can cancel the contract with no problem. And then they presented something completely different from what it was. We started paying them $179 per month, and then they increased that all the way over the time that we were with them to $779. When before we decided to cancel with them, we told them that we couldn't afford it time before that, before their contract supposedly renewed, because their contract, when we first signed up, they told us that the contract was for 1 year. So at the time, that was in 2015. So in 2019, I told the representative when he came to my office that at that time we were paying $479 a month. And we told them that at that price, it was really high for us to even afford that. And instead of what the representative said was that they could review that so that they can actually lower the price. And instead, they increased the price to $719. And they told us that we can cancel that because our contract was from 1 year. And then after that, from the lawyers that they hired, they sent us an agreement, which they never provided one when we first signed up with them. They never provided that kind of agreement to us. They never provided us a copy or anything of that agreement or any email with that agreement. And on that agreement says that the contract renews every year, which the representative never explained that to us. And the late representative that came to my office, they only came in to drop in some pens and to pretty much lied to us, because he said that we can cancel this contract at any time, which was not true. Under the agreement that they had before, which says that the contract's supposed to be renewed every year. And now they're trying to charge us even for a service that we didn't even use. So they're rounding a full year. They went from 479, increased it to 719, and then trying to charge us for a whole year of service that we didn't even use for something that they're not even providing. That's how they come up with an amount that we owe $10,000, when in fact that is not true.
Mr. Gonzalez, would you like to move for a continuance in order to hire an attorney?
If I have to see how I'm going to be able to afford one. With that said, another, let's say another date for court, or how would that work? I don't have a lot of the information or the knowledge in this matter.
Give me one moment. Mr. Lindeman, any objection to allowing a continuance for Mr. Gonzalez to attempt to hire counsel?
Judge, my only concern is Mr. Gonzalez has already stated he doesn't have the financial ability to seek counsel. If that's not the case and he needs time to seek counsel, then I'll leave it to the court's discretion, of course, to make that determination. But if he's unable to retain counsel, my only concern is that the case might drag out from there.
Mr. Gonzalez, have you spoken to an attorney to see what it would cost you?
I did. They weren't really able to give me like an amount on how much it would be, because pretty much the words from different attorneys that I spoke to was that this was something that they don't really know how long it will even take or anything like that, or pretty much told me that, in this kind of matter, any attorney would try to drag this out for a long time. I don't really have the means of the financial means for me to be able to afford this. The Carfax before, they offered me something for me to pay pretty much what it was due, and I told them, it was right in the middle of the pandemic, when everything was closed, we were not making anything, and I told them, at this time they told me they gave me an offer for $2,000 for me to pay, and I told them, this isn't even the amount that we used. We didn't even use any of the service, but they still wanted to get that kind of payment for $2,000. If they can set something, that even if it's not the amount that we use, that we can maybe pay for that and come to an agreement, on paying that offer that they made us, I can try to see how I can resource to pay that amount, and then we can probably be over with this and get this thing done, because they're going over the means to charge something, an extraordinary amount of something that we didn't even use.
And Judge, just to pipe in real quick, to the extent that Mr. Gonzalez wants to work out some kind of settlement or anything else, I'm more than happy to have that conversation with him outside the presence of the court. Looks like we did have some conversations about a month or so ago. Obviously, we didn't come to an agreement, but if the court's inclined to grant plaintiff's motion today, I can hold off submitting judgment for 10 or 14 days. Gives a chance to hopefully resolve it. We can either submit a stipulation or a judgment, depending if we get if we come to a resolution.
Yes, but if it's going to be something where it's going to be, because they tell me they want me to pay 85% of the $11,000 that they're charging me, which is an amount that is not even close to anything that we used. We didn't use any of that service. So they're pretty much, their company hides behind a contract to double the price, and they say, hey, if you're trying to opt out, then we're still gonna make extra money on you anyways. That's the way. I work in the car business, which is a used car business is one of the toughest jobs that there is, you know, and for the time that I've been here, I do right by everybody, you know, everybody that comes to buy a price. And then, you know, a small car business comes into a company that is just trying to like get us out of our money, you know, and it's unfair. It's unfair. And what they do with their representative is very deceptive, because he comes to my office, he tells me that I'm able to get out of the contract, and then when I get out of the contract, they tell me that I owe for the full year. You know, so it's how does a company, you know, hides under a contract and then sends a representative over to my office to tell me something that is completely different from what they're going to put me, you know, at a case later on. You know, they lie to us, and then now they're trying to get all of like a very big amount of money out of it.
All right, well, Mr. Gonzalez, I'm willing to give you a continuance if you want to hire counsel.
I want to see if there's any way that we can come to an agreement and trying to make a payment on what we used as of service.
All right, based on the information provided to the court today, I'm going to grant the motion for summary judgment. Mr. Lindeman, if perhaps you could speak with Mr. Gonzalez to try to resolve this prior to the court entering final judgment. It sounds like that might be a possibility.
Of course, Judge.
Okay. All right. And then, Mr. Lindeman, if you will submit to the court a proposed order via word to my judicial assistant. And then do you have Mr. Gonzalez's contact information so that you could perhaps try to reach a settlement agreement?
I believe so. Mr. Gonzalez, is your best phone number 239-265-3826?
Yes, that's correct.
Perfect. Thank you.
All right. And then I'll be waiting for that proposed order.
Understood, Your Honor. Thank you for your time.
All right. Thank you both.
Thank you very much.
All right. Bye-bye. All right, the next case on the 10 o'clock docket is the Kidwell Group LLC, doing business as Air Quality Assessors of Florida. AAO Dennis and Mary Ramalho v. United Property and Casualty Insurance Company, 20 SC 1807. I believe we're here on defendant's motion for summary judgment. If I could have the parties introduce themselves, starting with the plaintiff.
Yes, good morning, Your Honor. Attorney Leo Mannon on behalf of the plaintiff.
Good morning, Mr. Mannon.
And good morning, Your Honor. Kevin Pavlis on behalf of the defendant, United Property and Casualty Insurance Company.
Good morning, Mr. Pavlis. All right. I believe we're here on your motion, Mr. Pavlis.
Correct, Your Honor. The facts in this case are clear, and United is entitled to summary judgment as a matter of law, as plaintiff's assignment of benefits upon which they're relying to pursue this action is invalid pursuant to the requirements of Florida Statute 6277152. The underlying case here stems from alleged storm damages sustained by the plaintiff's assignor's home on or about September 10th, 2017. And the assignment of benefits giving rise to this action was executed on October 3rd, 2019, and is subject to the requirements of 6277152, as that statute went into effect on July 1st, 2019, and applies to all assignment of benefits agreements executed after July 1st. Section 2 of the statute, 2A specifically, provides a list of requirements for an assignment of benefits and states that an assignment agreement must include those. And Section 2D clearly and unequivocally states that an assignment agreement that does not comply with the subsection is invalid and unenforceable. Plaintiff's assignment of benefits is attached as Exhibit A to their statement of claim. and on its face does not comply with the terms and provisions as outlined in 6277152A1, A3, A6, and A7. And because the assignment is invalid, plaintiff has no standing to bring this suit, and accordingly, this court should grant summary judgment in favor of UPC. In paragraph 13 of plaintiff's statement of claim, plaintiff alleges that the insured executed an assignment of benefits to the plaintiff for assessment services to the insured directly relating to the loss in order to repair or replace damaged physical property. 6277152 states that, or defines an assignment agreement as any instrument by which post-loss benefits under a residential property insurance policy or commercial property insurance policy are assigned or transferred or acquired in any manner, in whole or in part, to or from a person providing services to protect, repair, restore, or replace property, or to mitigate against further damage to the property. By plaintiff's own statement in its statement of claim, they admit that they are under the purview of the AOB statute. And notwithstanding just paragraph 13, in fact, Your Honor, in paragraph 21, and despite now arguing that plaintiff is not subject to the application of 6277152, plaintiffs plead entitlement to attorney's fees pursuant to Florida statute 6277152. So I frankly don't understand any argument that plaintiffs do not see themselves as being subject to the statute if they are also simultaneously pleading entitlement to attorney's fees pursuant to that statute. A simple review of the assignment of benefits will show that it does not comply. Section 2A1 requires that an assignment of benefits be executed by both the assignor and assignee. In this case, the assignment of benefits, which is attached to the statement of claim, is signed by one insured, Mary Ramalho, and is not signed by any representative of the plaintiff. So it is in violation of 2A1 of 6277152 and is therefore invalid and unenforceable. Section 2A3 requires that an assignment of benefits contain a provision requiring the assignee to provide a copy of the executed assignment agreement to the insurer within 3 business days. The assignment of benefits at issue in this case is completely devoid of this provision. Therefore, it's in violation of that subsection of the statute and again is invalid and unenforceable. Section 2A6 of the statute requires that the assignment of benefits contain an 18-point uppercase bold notice informing the insured of the effects of an assignment of benefits in order to curtail potential assignment of benefits abuse. The assignment of benefits being relied upon in this case is completely devoid of this provision. Again, that is a clear violation of the statute, rendering the assignment of benefits invalid and unenforceable. And Section 2A7 requires that the assignment of benefits contain a clause stating that the assignee would indemnify and hold harmless the assignor from any liabilities, damages, losses, and costs if the policy restricts assignments of benefits. Again, as with the previous mentioned provisions, the assignment of benefits in this case is completely devoid of this provision in violation of the statute and is therefore invalid and unenforceable. The statute was written clearly. The assignment agreement requirement section uses words of command. It states that you must include those things. It does not provide any wiggle room for companies which choose to use an assignment of benefits to try and circumnavigate any of those provisions. And based upon the clear and undisputed facts in this case, the assignment of benefits being relied upon here is invalid and unenforceable. And as a matter of law, United is entitled to summary judgment. I would like to reserve some time for rebuttal, if that is possible.
All right. Mr. Mannon?
Yes, Your Honor. First, defendant's argument regarding plaintiff pleading entitlement to attorney's fees under 6277152 can't be considered by this court today as it was not raised in our motion for summary judgment. It is thus improper for defense counsel to make the argument in the hearing for the first time without giving plaintiff the opportunity to respond. Second, this issue was brought before Judge McHugh in Lee County in an unrelated case, which was SFR Services LLC versus American Integrity Insurance Company of Florida in the Circuit Court for Lee County. The case number is 2020 CA 5940, which he entertained an identical motion regarding the assignment of benefits being invalid for not complying with 6277152. Judge McHugh wrote a 2-page order stating, and it supports my argument that I'm going to make, that the statute cannot be applied when the policy was in effect prior to the new law going into effect, pursuant to the Florida Supreme Court ruling in Menendez versus Progressive Express Insurance Company, Inc. For the court reporter, the citation is 35 Southern 3rd 873. It's a Florida Supreme Court case from 2010. In that case, the facts were a loss occurred. Services were then performed after the loss, and after services were performed, the Florida legislature enacted a new statute which imposed new obligations in order for a plaintiff to sue an insurance company. The insured moved for partial summary judgment. The trial court granted it on the grounds that the statute could not be applied to them. The third DCA overruled the trial court, and the third DCA's ruling was in conflict with another DCA, so the Florida Supreme Court took up the case to resolve the conflict. What the Florida Supreme Court ruled and held is that a trial court is required to look at the law that was in effect when the policy went into effect, not the date of loss, not the date of service, and not the date a lawsuit was filed. In this particular case, Your Honor, the lawsuit or the policy went into effect on June 21st, 2017. That's undisputed. That's part of the court record. In June of 2017, there were no laws on AOBs. There were no restrictions. There were no requirements. For those reasons, 6277152, which went into effect on July 1st, 2019, went into effect after the policy. And pursuant to the Florida Supreme Court ruling in Menendez, cannot be applied in this matter. Furthermore, Your Honor, there's two second DCA cases which state that even if a trial court disagrees with case law that is binding, it's still required to follow it. That would be PIM versus PIM. And for the court reporter, PIM is PIMM versus PIMM, 568 Southern 2nd 1299. It's a second DCA case from 1990, as well as Chapman versus Pinellas County, 423 Southern 2nd 578. It's a second DCA case from 1982. Both of those cases stated that the trial court is bound to follow case law that is binding, even if they disagree. In this matter, is plaintiff's position that the court is bound to follow the holding of Menendez, which states it cannot apply a statute that went into effect after the policy went into effect. For those reasons, is plaintiff's position that they are not required to comply with 6277152, and that this motion for summary judgment should be denied.
All right. Thank you, Mr. Manna. Mr. Poplis?
Yes, thank you, Your Honor. First, just briefly regarding counsel's argument that it's improper for me to make an argument regarding the contents of plaintiff's complaint. The argument is in response to plaintiff's response to the motion for summary judgment, positing that they are not subject to the requirements of 6277152. And frankly, plaintiffs are the masters of their own complaint. It's part of the court file. It's clear as day. It's attached to our motion for summary judgment. It's a statement made by them in their own complaint that they filed. And so there's no reason that the court can consider a statement made by the plaintiff in their own complaint stating that they have a prayer for attorney's fees pursuant to 6277152. With regard to counsel's argument that retroactive application of the statute is precluded in this case, there is no retroactive application that we are seeking here. In fact, in Menendez, the case that was cited by counsel, it stands for the proposition that a statute may not be retroactively applied to an insurance contract issued prior to the enactment of a statute if that statute impairs a vested right, creates a new obligation, or imposes a new penalty. Here, the statute, the 6277152, does not at all comment on the insurance policy. Rather, it discusses a separate, distinct contract, which is an assignment of benefits contract. An assignment of benefits is a creature of law, not a creature of the actual policy. This is not something that affects the rights of the insured under the policy. It does not affect the rights of the parties to the policy. An assignment of benefits does not mean that the AOB vendor becomes an insured under the policy from the perspective of when it was initially issued. The statute is designed to protect insureds and provide insureds more rights, not limit those rights. And the statute is not applying retroactively to limit rights. It discusses assignment agreements entered into after July 1st, 2019. It does not reference anything regarding the policy or when the policy was issued. Had the legislature wanted to further restrict the application of 6277152, it certainly would have included a restriction like that. Instead, it simply states that it is applicable to all assignment of benefits agreements signed after July 1st, 2019. As I stated, the assignee was not a party to the insurance contract at the time it was issued and cannot use Menendez to create new rights for it, a non-party to that insurance contract. Any reliance on Menendez is misplaced, and in fact, the court should instead look to De La Fuente versus Florida Insurance Guarantee Association, 202 Southern 3rd 396. That's a Florida Supreme Court case out of 2016, which discusses the retroactive application of the sinkhole statute and its application to the forced place policy insurer Florida Insurance Guarantee Association. In that case, the insured argued that FIGA was bound under the terms of their 2009 contract, and since they stepped in the shoes of the insurer as the forced place carrier after HomeWise's insolvency. The court in that case reasoned that Menendez did not prohibit the retroactive application of the 2019 sinkhole statute, since FIGA was not and is not a party to the initial insurance contract between HomeWise and the insured. Further, the court reasoned that because the obligations of FIGA to the insured are a creature of statute and not the insurance policy, the law that is in effect with FIGA assumed the policy when FIGA assumed the policy is the one that applies. Similarly, the AOB was not a party to the insurance contract, and the AOB's obligation to the insured are created under a statute, not the insurance policy. Thus, the court should apply the law that was in effect on the date the AOB was signed, not when the policy was entered into. Additionally, the Second District recently decided an appeal in the matter of Webb Roofing and Construction LLC versus FedNat Insurance Company, 2021 Florida Appellate Lexus 4799. That's a Florida Second DCA 2021 decided on April 7th, 2021. While this case does not discuss necessarily directly the application of the assignment of benefits statute, the case is under extremely similar circumstances to what we have here. It's a post July 1st, 2019 assignment of benefits regarding a Hurricane Irma claim with a date of loss from 2017, and looking to a footnote in that case, it does simply state that the assignment of benefits at issue in that case was executed after the statute went into effect and is subject to the requirements of that statute. The court just accepted as true the fact that the statute would apply to an assignment of benefits executed post July 1st, 2019. Counsel has referenced another court order from Judge McHugh. However, that wouldn't be binding on this court. I will admit I don't know the status of that order. I don't know if it's been appealed, but the Second DCA has put out a case in which they have just summarily accepted an assignment of benefits that was executed post July 1st, 2019 with regard to a Hurricane Irma claim, and found that the requirements of 6277152 apply to it with regard to an issue of appraisal. And so again, I do not believe that retroactive application of the statute is an issue in this case. It's not. We're simply seeking application of the statute. And again, for all of the reasons previously stated, United believes it's entitled to summary judgment as a matter of law and respectfully requests that this court grant the relief requested.
Your Honor, if I may, I need to object to everything that defense counsel just argued in rebuttal, as it's trial by ambush, it's bad faith, as every case that he just cited to is not in their motion. He is ambushing me as the plaintiff's attorney with case law without the opportunity to review it in the hearing. Again, there is binding case law, Bank of America, Williams versus Bank of America Corporation, 927 Southern 2nd, 1091. It's a fourth DCA case from 2006. There is no contradictory DCA cases on the issue, which states that the court will commit reversible error when they consider arguments made by a party for an MSJ that was not raised in their motion. Again, he's referencing a second DCA case regarding an assignment of benefits for appraisal, which did not raise in his motion, gave plaintiff no opportunity to review and to draft a response to. He references another case that was not in their motion. His motion is entirely void of any case law, yet he wants to ambush me in the middle of a hearing with case law that he never disclosed before.
Judge, it's not an ambush regarding case law or things that needed to be included in our motion. This is rebuttal argument to the arguments raised by plaintiff in their response to our motion for summary judgment, which was filed 5 days ago, I believe, maybe 7 days ago. And I did research regarding it and found case law. There's no requirement that I go back and amend my motion for summary judgment. It's not a basis for the argument in our motion for summary judgment. It's rebuttal arguments to plaintiff's position, and there's no reason that this court couldn't consider those arguments.
I'm in agreement that because it was on rebuttal, that it doesn't need to be included in the motion for summary judgment. So I'm going to overrule the objection. Mr. Mannon, let me ask you, I find in your response, which I don't think you touched on this, you argued that the assignment agreement definition doesn't apply to this case because of the types of services that were provided. Can you expand on that, please?
Yes, Your Honor. So that particular argument was raised by one of our associates. He's that drafted the response. We are not, so I'm, I guess on the record, we're not making that argument. Our argument solely here today is that 627-7152 cannot be applied to this case because the policy went into effect prior in accordance with the Menendez court ruling. So as far as that particular argument, we are not moving forward with that argument. But to give background to the court, the statute, as to why my associate put that in there, it lists services that would be contemplated and governed by the statute. However, the statute does not state that my client's services are included or excluded from being governed by that statute. But our only argument we're making here today is that the court must follow the Menendez ruling and cannot apply 627-7152 to the policy that went into effect prior.
All right, I'm going to reserve ruling on the motion for summary judgment. I'll have a an order. Let me look at my calendar. I'll have an order issued by the end of May. So about 30 days.
Okay.
Sorry, I'm just taking some notes here. All right, anything further?
No, Your Honor.
No, Your
All
Honor.
right, thank you both. Have a good day.
You too.
Thank you, court reporter. All right, any questions, Tommy?
No, Your Honor.
Yes, the attorney is supposed to provide that. Okay. All right, we got a few minutes before the 11 o'clock group. I'm just gonna turn off my microphone and video.
Okay.
Okay, thanks.
Thank you.
Case number 21CC270. Could I have the plaintiff's attorney introduce themselves?
Your Honor, Jeff Bluestein for the plaintiff, Todd Ogden as trustee of the Edna Means Revocable Trust dated 9/27/2002.
All right, thank you. And do I have anyone for the defense? Does not appear so. Okay. I believe we're here on the motion for summary judgment. Is that correct, Mr. Bluestein?
We are, Your Honor, and I actually spoke to the only defendant that has filed a response several days ago and made sure that he'd been provided with the Zoom instructions. He provided me with his email address at that time, and I then emailed him the Zoom instructions. So I don't know if the court wants to wait and give him an opportunity to appear. I know there's a second hearing, and that's probably, I don't know. I like giving folks the benefit of the doubt, I guess.
I understand. All right, we'll recall your case then.
Thank you.
Thank you. All right, the next case we have is TD Bank USA v. Pascali Najas, case number 19CC790. If I could have the parties introduce themselves, starting with the counsel for the plaintiff.
Daphne Ganthier for the plaintiff, Judge. Good morning.
Good morning, Ms. Ganthier.
Alan Hamish on behalf of the defendant, who's also sitting with me. I just turned on the wrong camera, so.
Okay. All right. Good morning, Mr. Hamish. All right.
In essence, Judge, this is my motion for extension of time set by the plaintiff in this case. It's been a long time coming with COVID. I kind of lost track of this. The plaintiff lawyer and I spoke yesterday, working through settlement options, and if I can have 10 days to file a response, and we'll just move the case forward if we don't get settled. Maybe a quick mediation.
All right.
10 days will work, Judge. That's fine.
Yep. Okay. All right. Motion is granted. Mr. Hamish, if you'll send over a proposed order in Word format to my judicial assistant, we'll get that filed today.
What's your judicial assistant's name? Because I always forget her email, so I got to look.
Julianne Romanelli.
Okay.
J Romanelli at ca.cjis20.org.
Okay. Thank you, Your Honor.
All right. Thank you, Mr. Hamish. Thank you, Ms. Ganthier.
Thank you, Judge.
All right. Well, Mr. Bluestein, that didn't take long.
Yeah, Your Honor, I like I said, I like to give folks some time, especially when they're pro se, as this gentleman is. I don't know what I'll defer to the court, but.
I understand. We can give him a few minutes. Give me one moment here.
Thank you, Your Honor.
Thanks. Mr. Bluestein, my judicial assistant did hear from Mr. Bailey this morning, so she's contacting him to see if he's having some difficulties. So as soon as she updates me, I'll be right back with any information.
Thank you, Your Honor.
All right, thank you. All right. Looks like we have Mr. Bailey present.
Yes, sir.
All right.
Sir.
I'm doing well, Mr. Bailey. This is Judge Blake Adams present. Are you able to start your video?
I'm trying to, yeah, start my video. There you go.
Okay, very good. All right. And again, this is case number 21CC270. We have Mr. Bluestein present. Mr. Bluestein, this is your motion for summary judgment, so I'll let you proceed.
Thank you, Your Honor. Our motion for summary judgment and all summary judgment evidence was filed more than 20 days ago, so we've satisfied the requirements of 1.510 Rules of Civil Procedure. This is an action for one count of unlawful detainer by the property owner, the Edna Jean Means Trust, dated 9/27/2002. Prior to 2002, the property owner was Edna Jean Means, who is an 84-year-old woman in failing health. She conveyed the property to the trust in 2002, and then she has been the trustee ever since, until March of 2020, when she could no longer manage her affairs, and she appointed Todd Ogden as the successor trustee, and those documents have been filed with in connection, or attached to a notice of filing and attached to an affidavit from Todd Ogden stating that he has been served as the trustee since March of 2020. When Mr. Ogden took over, he found Mr. Bailey living in the house and asked him to leave. Mr. Bailey made promises of leaving, promises of paying something, although we're not aware of any rental agreement of any kind. And nothing ever happened to this day. I think Mr. Bailey has paid a total of $300 for the benefit of living in this property for the past year. And like I said, we're not aware of any rental agreement. Mr. Bailey, we believe, was let into the house by Edna's nephew, Jackie Means, who died in February of 2020, which is sort of how this sort of arose. So for our intents and purposes, and for purposes of unlawful detainer, we believe Mr. Bailey is a squatter and nothing more. He has offered to pay no rent. He has filed an answer in this case. The only defense that he's raised is that Jackie Means, Edna Means' nephew, gifted him the property. Jackie Means was never an owner of the property. Jackie Means was never a trustee of the trust. So even if Jackie Means had chosen to do such a thing, he had no authority to do it. Aside from that, we've served this written request for discovery, interrogatories, request for production, and a request for admissions, asking for any proof of any written agreement of any kind. We did not receive anything. The request for admissions actually asked Mr. Bailey to admit that there is no document he's relying on for any defense of this case. So, as part of our summary judgment motion, I mean, we've referenced the statute of frauds. I'm sure the court is familiar with that. Any interest in property, it's any interest in property to be conveyed for longer than a year or permanently, such as a deed, has to be in writing. We're not aware of such a writing. Mr. Bailey has filed no affidavits in opposition to this motion. And frankly, at this point, I mean, it's, Mr. Bailey told me the other day, the water may not be on, the electric may not be on. I mean, this is becoming a health hazard. Property is owned by the Edna Jean Means Trust. Proof of that has been filed, attached to the affidavit in support of this motion that we filed, which is a deed and the affidavit of Todd Ogden stating that it hasn't been transferred. So at this point, we believe we've satisfied our burden, and then we would ask the court to remove Mr. Bailey from the property forthwith. And as the court knows, or hopefully knows and has a copy of, we sent a proposed order to the court in advance of this hearing. And the court should have that in its possession. We also sent a copy to Mr. Bailey, so if he wanted to review it and object to it, he certainly could. But we're not aware of any defenses that would support Mr. Bailey remaining in this property. And we would like him to leave, and we would like you to sign that order. Thank you, Your Honor.
All right, thank you, Mr. Bailey, do you have a response?
Yes, sir, I do. In the first place, Jackie Means is Edna's son, not nephew. And I grew up with Jackie since 4th grade. Now, Jackie was failing in L2. I found him dead on his couch over a year ago. Before that happened, Jackie had promised that I could have this house. Now, I don't have anything in writing of that. I have an 11-year-old daughter here. Now, I have switched the power over to my name. When I was paying Jackie rent, all the money that I was giving him was also paying for the water and the electric. But when the power went out, I had to go back and pay the back electric because unbeknownst to me, Jackie hadn't been paying. They kept it open. It was, I don't know how much money, I don't recall, but it took me a lot of time to get that money together because of the COVID thing. Work was slow. I'm a single father raising an 11-year-old child here, and being that the water had been shut off just recently for some reason, I've had to take my child and let her stay on my aunt's couch, and I take her to school. She comes here to go to school with the hotspot thing on her computer, and then I take her back to my aunt's house when I'm done working. Now, there's a little bit more going on here than what Mr. Bluestein is talking about here. Edna has dementia and Alzheimer's, and I don't see how any way she could sign anything over to anybody anyways. That there's something going on. I talked with the neighbor across the street, Larry, who was also on that lease or on the trustees thing. Larry Barsano.
Your Honor, for the sake of posterity, I'm going to object to all this testimony, but if the court is inclined to listen, I understand.
I'm gonna
Go ahead.
sustain the objection. Mr. Bailey, let me ask you this. You said you were paying rent. Do you have a copy of the rental agreement?
No, sir. I've got text messages from Jackie. I've got, Jackie and I grew up together. We were best friends since 4th grade. Everything we've done has been by handshake, sir. I have nowhere to go until I can get the money up to go. The thing about it is, sir, there's something going on a little bit deeper than what's happening here. I know what Jackie promised me, and I understand that this trust is I guess apparently his name is not on it. I don't understand why that is, and I don't understand why he's saying it's his nephew, or he's the nephew of her when it's the son. I took Jackie back and forth to visit his mother 3 times a week, and the neighbor across the street said, Larry Barsano, who's also on this thing, sir, says that there's a little something funny going on here because the other gentleman, Todd Ogden, is already starting to fix the other house up to sell it. So I don't quite know what's happening here, sir, but the problem is right now we are willing to do what we got to do. I know that this house is not going to be mine. I understand this because Jackie had promised me it and there's nothing in writing. But right at this moment, sir, we have nowhere to go until I can get up enough money to find a place. I don't understand why they shut the water off on us when I've lived here for 5 years almost, sir. I've been taking care of Jackie for 4 years when he got sick. The thing is, sir, that there's something a little bit deeper, and I would like the opportunity now that I'm back working to get an attorney to kind of voice everything for me because I'm not good at this stuff. If you could give me a little time to get my attorney to be able to do something about this, to at least try to bring out the real truths in this matter, I would appreciate it, the court doing so. We have nowhere to go. I have a daughter to raise. I have a disabled girlfriend who's got fibromyalgia that I've got to take care of. She has no insurance. So financially, I'm strapped right now. Now, the attorney, Mr. Bluestein, has gone as far as offering me money to move out. I thought that was kind of strange, but maybe that's part of the system. I don't know. I've never been in this situation before. So that's why I wanted an opportunity in the next couple of weeks here to get up enough money to get an attorney to be able to dig into this a little bit deeper and find out what's truly going on, and also bring in the other guy, Larry Bassano, who's actually wants to be a part of this too, who was actually on this trust thing too, and he doesn't understand why he's no longer on it. I know Jackie's mother. I love her. I understand that she's in bad health, but I also understand that she's got Alzheimer's or dementia, and I don't understand how she can even sign anything over to Mr. Ogman at this particular time when she's incapable of even, half the time she doesn't even know who is, you know, let alone sometimes her son Jackie would tell me that she didn't even know who he was. So there's something a little bit funny going on here, sir, other than what's happening here today. So I'd like the opportunity, if possible, now that I'm back to working, to be able to get, you know, a cheap lawyer that might be able to come to my defense, even if the outcome is we have to leave. But right at this moment, we have no work, and I've got the power over in my name. The water, I don't know what the deal is there. I'm not sure how much it is and who can pay it. It's not in my name. So it was intentionally shut off.
All right. Thank you, Mr. Bailey. Mr. Bluestein, anything else from you?
Sure. A couple things. First of all, I mean, again, it probably shouldn't even come in, but there was a reference to an offer of payment. Yeah, that was a cash for keys offer that was made before we filed this lawsuit, in the hope that we didn't have to endure 3 months of waiting, you know, as is typically the case when you file a lawsuit, in order to remove an occupant from a property. That offer was not accepted, and Mr. Bailey remains in the property and has not paid anything. The other thing I would point out, and the court asked a very salient question, which is, you know, what about a lease? Jackie Means passed away on February 21st, 2020. So to the extent that a lease was signed the day before Jackie died, it would have expired by now anyway, because we can't have more than a 1-year lease without witnesses, and we certainly didn't have that. And that wasn't alleged. So you know, and I guess as it relates to the trust, all I can say to the court is the trust documents were, I think they were produced by George Wilson. I'm sure the court is familiar with George Wilson. As a general rule, George Wilson doesn't accept signed trust documents from people lacking capacity. So we think, you know, Mr. Bailey's been in this property rent-free, payment-free, everything free long enough. And as for the utilities,
I paid Jackie a ton of money.
Mr. Bailey,
as
for the utilities, we don't know whose name it's in. The first time I found out that the water was shut off, Mr. Bailey told me. So I presume that the utilities were either in his name or Jackie's name, and nobody ever paid him. So one of the things that we stand to inherit when Mr. Bailey leaves is a fairly large water bill with interest running at 18%, I'm sure.
Oh, I'll pay the water. I'll pay the water. But that wasn't part of my handshake with Jackie when I moved in here. I fixed this place up. I've done a lot of work on this house just to be able to live here, and I gave Jackie over $10,000 to stay here, sir. The problem is right now, with the situation of everything going on right now, I'm just now getting back to work. We don't have a place. I'd gladly leave. We would gladly leave, but as it is right now, we don't have the money. I'm trying to get money together now to be able to get a place. I thank you for your offer on money, but $1,500 is not going to get me out of this house for rent. I can't even rent a place for that for a week, you know, in Naples. Your Honor, I'm asking for a little more time to try to get an attorney together here to be able to, or at least to be able to get up enough money to get a place. I've got an 11-year-old daughter I raise alone. I'm a single parent, and I've got a girl who's disabled, girlfriend who's disabled. And as it stands right now, sir, with all the COVID going on, that from my understanding, the Center for Disease Control and Prevention, there's an act right now, a section act that can't do anything till June anyways, but that's besides the point. I'm willing to go, but we have no money to leave.
Mr. Bailey, the court is very sympathetic with your situation. Unfortunately, the problem is you've provided the court with no evidence to support any reason why you should be allowed to stay there. And while the court typically would allow an unrepresented party an opportunity to try to seek legal counsel, if the court thought you had some proper defenses. In this case, there are no defenses that you've raised that would be proper in this case. And I know you brought up the CDC thing regarding COVID and the pandemic. Unfortunately, that doesn't apply in this type of situation. And so I have no choice but to grant the plaintiff's motion for summary judgment at this time.
I understand. But sir, is there any time limit? I mean, can you have a little time where I can try to get some money together here, please?
Your Honor, this has been pending since February. This is old. Mr. Bailey has had a lot of time, with all due respect.
And I haven't been working either until now. And that's the problem. I need some time to get money to get a place, sir. I'm begging the courts to please allow this for my daughter's sake, for my sake, for my girlfriend's sake.
Mr. Bailey, unfortunately, there's nothing that I can do pursuant to the law that would allow you additional time, and I apologize for that. Mr. Bluestein, if you'll prepare the order.
Your Honor, you actually should have the order.
Oh, okay. All right.
How long do I have? Or we have?
Your Honor, if I can respond to that, I can give him my best guess.
You may.
Mr. Bailey, presuming the judge signs the order today, the order is filed with the clerk today. My best guess is, based upon the timing of writs of possession and execution of writs of possession, you've probably got until next Wednesday or Thursday.
All right. I thank you for your time, Your Honor. Thank you, Mr. Bluestein.
All right. Thank you, Mr. Bailey. Good luck to you.
Thank you, Your Honor.
All right. Thank you, Mr. Bluestein. All right. I believe that will conclude today's civil motion hearings. Tommy, is there anything else that we need to discuss before we end today's court session? Tommy, I can't hear you.
No, Your Honor, I pretty much got everything.
Okay. All right. Very good. That will conclude today's court proceedings in civil court. Thank you, everyone.